Hello guys, today we are looking into accounts of company under Companies Act 2013. Accounts of companies. So section starts from section 128 of the Companies Act 2013. Let's go one by one. It starts with the section 128 and 29 types of accounts to be maintained, that is the books of account, relevant books, papers, financial statement. 29, that is financial statement. 130, reopening and recasting of accounts. Reopening in case any errors or in order to change, they will reopen, that is under section 130. If there is any revision of accounts voluntarily, section 131. 130 to 133, NFRA and power of CG, accounting standard AS. Next, audit reports and board reports, section 134. Corporate social responsibility, section 135. 136, 137, rights of a member and filing of financial statement with the registrar. And the last, under accounts in Companies Act 2013, section 138, internal audit. Okay, first comes section 128. Heading is books of accounts etc. to be kept by company. So by default, this section is applicable for the partnership firm? No. Sole proprietor? No, it is applicable to the company. Books to be maintained. Company shall prepare books of accounts, books and papers, financial statements. What and all included in financial statement? 5 things. We'll see later on. That is comes under section 129. So these 3 things keep at its registered office or any other place in India as the board of directors may decide. So place of books of account, it will be at registered office. Say MCQ question, probable question, possible that can books of accounts be placed at other than registered office? Yes, no. Answer is yes, but board of directors approval is required. So as per the decision of the board of directors. Open for inspection by the directors. So it is open for directors to inspect. Preserved for 8 years. Failure in compliance, there is a jail 1 year, up to 1 year, maximum 1 year, or fine 50,000 to 5 lakh, who is responsible of the default, or both. So there is a MCQ probable question again. Books of accounts should be kept for preserved for 7 years. Answer is no. For 8 years they should preserve. Let's say, let's make you are at a final level, let's make it a difficulty Vouchers, books of accounts are maintained for the 8 years, but vouchers are not kept for 8 years, but it is there for 6 years. Last 2 years is not there. Is this valid? Whether they follow section 128? Not about the books of accounts, vouchers. It is failure of section 128 because vouchers also should be kept for 8 years. So this is a probable MCQ question. General requirement, it should be true and fair view. It should follow a double entry system and the accrual system. Let's say MCQ probable question. ABC Limited follows cash basis for its accounting. Can it follow ABC Limited? Answer is no. They cannot follow cash basis. They have to follow. It is a compulsory to follow accrual. Accrual concept should be followed, not cash basis. MCQ 4. It's all basic questions. ABC Limited following the single entry book system. Is it correct? Answer is wrong. They have to follow double entry bookkeeping system. It is a compulsory. This all mentioned in section 128 of the Companies Act. Let's move on. They explained what is the meaning of the books of account. That you know, book and paper. See, it includes accounts, deeds, vouchers, writing, documents, minutes, registers maintained on paper or in electronic form. Next comes place of keeping books of account. Section 128 subsection 1 requires every company to prepare and keep the books of account and other relevant books and papers and financial statement at registered office. At registered office, provided all or any of the books of accounts may be kept at such other place in India as the board of director may decide. So if it is other than registered office, who will decide? Board of directors. Where such decision is taken by the board, the company shall within 7 days thereof file with the registrar a notice in writing giving full address of that other place. If it is other than the registered office, board can decide, but the one condition is within 7 days they have to give a notice to the in writing to the registrar of that place. Next comes maintenance of books of accounts in electronic form. A company has an option of keeping books of account or other relevant papers in electronic mode as per rule 3. So again MCQ 4. ABC companies cloud, they are saving or making or preparing books of accounts in cloud computing. Is it okay whether they satisfy the Companies Act of the provisions? Yes, they can have in electronic mode. Okay, you are at a final level. Let me make it little bit difficult. They are maintaining at a electronic mode, that is the ABC Limited. Server in physical server in Switzerland. Indian company, server in physical server in Switzerland, whether they are following the provisions of the Companies Act. No, the physical server should be in India. Such books of accounts or other relevant books or papers maintained in electronic mode shall remain accessible in India so as to be usable for the subsequent reference. So it should be accessible in India. The information contained in the records shall be retained completely in the format in which they were originally generated, sent or received. Okay, original should be there, should be unaltered, complete. Next comes information received from branch office shall not be altered. No alteration in case of branch office also. Fourth, the information in electronic record of the document shall be capable of being displayed in eligible form. Fifth, point number 5, the backup of books of account and other books and papers of the company maintained in electronic mode, including at a place outside India, if any, shall be kept in servers physically located in India on a periodic basis. If it is a place outside India, it should be kept in servers physically located in India. The company shall intimate to registrar on an annual basis at the time of filing a financial statement following relevant information related to service provider: name of the service provider, internet protocol or address of service provider, location of the service provider. Where the books of account and other books and papers are maintained on cloud, such address provided by the service provider. Next comes books of account. Branch office. Where a company has a branch office in or outside India, it shall be deemed to have complied with the provision of subsection 1 if proper books of account relating to the transaction effected at the branch office are kept at the office, and proper summarized returns periodically are sent by the branch office to the company at its registered office and are kept open for inspection at the registered office of the company or at such other place in India by any director during business hours. So again, one more probable MCQ question. ABC Company Limited, Mr. A is the director of the ABC Limited, is the director. Question is, can he inspect the books of accounts of the ABC Limited? Yes, that is a basic thing. Inspection is, but he came at 9 p.m. But business or for this company is 9 a.m. to 6 p.m. Can you inspect at 9 p.m.? Answer is no. It should be at business hours. Inspection by directors. Next comes, you are at final. Let me give MCQ question number 6. Can nominee director, let's say, is a nominee director. He came at 5 p.m. Can he inspect? He's a nominee director. Can he inspect? Yes, he can inspect even if he is a nominee director. That is a question number 6. So nominee director can inspect books of account at business hours. As per section 28 subsection 3, any director can inspect the books of account and other books and papers of the company during business hours. Such inspection may be done by any type of director, nominee, independent, promoter, whole time. The proviso to subsection 3 provides that a person can inspect the books of accounts of subsidiary only on authorization by way of resolution of board of directors. MCQ 7. ABC Company Limited. They have, this is a holding company. They have subsidiary company of XYZ Limited. Subsidiary company. Mr. A is the director of holding company ABC Limited. Is the director. Can Mr. A inspect the books of accounts of the XYZ Limited? Answer is yes, with condition. What is that condition? Condition is board of directors approval. Resolution should be taken for inspection. Only on authorization by way of resolution of the board of directors. The director can seek the information only individually and not by or through his attorney holder or agent or representative with respect to financial information maintained outside the country. Let's say MCQ multiple choice question number 8. ABC Limited, Indian company. This have some Switzerland countries, some its financial info. They have business there also. Now Mr. A, director, appoints Mr. Z, that is agent of Mr. A is a director of ABC Company Limited. The financial information of ABC Company Limited in Switzerland. He sends Mr. Z to seek information of financial information in Switzerland, that is outside India. Can Mr. Z seek information on behalf of Mr. A? Answer is no. Then he individually should seek information. He cannot send his representative or a agent to access or seek financial information if it is a maintained financial information maintained outside the country. Now comes period for preservation of books. The books of account of every company relating to a period of not less than 8 financial years immediately preceding financial year, or where the company had been in existence for a period less than the 8 years, in respect of all the preceding years, together with vouchers relevant to any entry in such books of account, shall be kept in good order. The provision of income tax shall also be complied within this regard. Where an investigation has been ordered in respect of company, the CG may direct that books of account may be kept for such period longer than 8 years as it may be deemed fit, and give direction to the effect. So next question, MCQ 9, multiple choice question 9. ABC Company Limited incorporated in the year 2011. Now 2020 there is a investigation is going on, inspection. So government tells here CG notifies to that company you have to prepare, maintain records of 9 books of accounts should be kept for 9 years. It should be preserved for 9 years for the purpose of investigation. So CG notified 9 years to preserve the books of account, but ABC Limited claims that as per Companies Act 2013 section 128 specifies that it must be for 8 years, so we are not keeping for 9 years. They are following 8 years, not 9 years, but the contention of the companies is invalid. Why? They have to follow CG order or a notification. Not 8 years, they have to follow 9 years. So CG have the power. Persons responsible to maintain the books. Who is responsible? As per section 128 subsection 6, the person responsible to take all the reasonable steps to secure compliance by the company with the requirement of maintenance of books of accounts shall be MD, full-time director in charge of finance, CFO, any other person of a company charged by the board with the duty of complying with the provision of the section 128. If they don't comply, if there is any default, then they have to, there may be imprisonment up to 1 year or a fine 50,000 to 5 lakh for the company, or both. Penalty in case of aforementioned persons referred in that above person fail to take a reasonable step to secure compliance, they shall in respect of each offence be punishable with imprisonment for a term which may extend to 1 year, or with fine which shall not be less than 50,000 rupees but which may extend to 5 lakh rupees, or both. Example, XYZ Limited wants to maintain its books of account on cash basis. No, they cannot. They have to follow accrual basis. Is this valid act of XYZ Limited? The Companies Act 13 wide section 128 subsection 1 requires every company to prepare books of account and other relevant books and papers and financial statement for every financial year on a accrual basis and double entry system of accounting. No exception has been given by the act to any class or classes of companies from the above requirement. Hence, XYZ Limited cannot maintain its books of accounts on cash basis. They have to follow accrual basis. Let's move on to section 129, that is a financial statement. So when you say financial statement as per section 2 subsection 40, it includes 5 things. One is a balance sheet, P&L or income and expenditure account, cash flow statement, statement of changes in equity if there is applicable, or any explanatory notes annexed to or a forming part of financial statement. So these are the 5 things: balance sheet, P&L, cash flow statement, changes in equity, notes. However, the financial statement with respect to on-person company, small company, dormant company may not include the cash flow statement. So next question will be ABC Company Limited. It is a small company as per the definition under Companies Act. Whether they have to follow section 128 with regard to books of accounts? Yes. Whether they have to follow section 129 with regard to financial statement? Yes. Question asks, they are not maintained financial statement as per section defines, that is a they have to maintain balance sheet, statement of P&L, cash flow statement, changes in statement of changes in equity, explanatory notes. But this ABC Company Limited is not maintained cash flow statement, whether they follow the section 129 or is there a violation of provision of the Companies Act? Answer is no, there is a no violation. They followed proper provision of the, so this CFS is not mandatory for the small company. Financial statements should be prepared for financial year and as per the requirements of Schedule 3. Financial year, section 241, subsection 41. In relation to any company or a body corporate means a period ending 31st March, that you know, very easy. Schedule 3, that also you know, that division 1, division 2 and all deals with the AS and Ind AS, division 2 Ind AS, division 1 AS. Next comes true and fair view. As per section 129 subsection 1, the financial statement shall give a true and fair view of the state of affairs of the company or companies. It shall comply with the accounting standards notified under section 133 and shall be in the form of or forms as may be provided for different class or classes of companies in Schedule 3. Non-applicability. Provided further that nothing contained in this subsection shall apply to any insurance, banking or a company engaged in the generation or a supply of electricity, or to any other class of company for which a form of financial statement has been specified in or under the act governing such class of company. So you cannot tell they are not follow Schedule 3 for the banking company or a insurance company. They have their own special act. Provided also that the financial statements shall not be treated as not disclosing a true and fair view of the statement of affairs of the company merely by reason of the fact that they do not disclose. Insurance company, they have Insurance Regulatory and Development Authority Act and as well as Insurance Act. Banking company, matters which are not required to be disclosed by the Banking Regulation Act. Company engaged in the generation or supply of electricity, matters which are not required to be disclosed by the Electricity Act 2003. Company governed by any other law, matters which are not required to be disclosed by that particular law. Next subsection under section 129, laying of financial statements. At every AGM of a company, the BOD of the company shall lay before such meeting financial statement for the financial year. They have to present, they have to lay the financial statement in the AGM. CFS, that is subsection 3. Where a company has one or more subsidiaries or associate companies, it shall, in addition to financial statement provided under subsection 2, prepare a CFS of the company and all subsidiaries and associate companies in the same form and manner as of its own and in accordance with the applicable accounting standards, which shall also be laid before the AGM of the company along with the laying of its financial statement under subsection 2. The company shall also attach along with the financial statement a separate statement containing silent feature of financial statement of its subsidiary or subsidiaries in form AOC 1 as per Rule 5, Company Rules 2014. Provided further that the CG may provide for the consolidation of accounts of a company in such manner as may be prescribed under Rule 6. Explanation: for the purpose of this subsection, the word subsidiary shall include associate company and joint venture. Manner of consolidation of accounts. The consolidation of a financial statement of a company shall be made in accordance with the provisions of Schedule 3 of the Act and applicable AS. In case where company is not required to prepare CFS, a company covered under subsection 3 of the section 129 which is not required to prepare CFS under AS, it shall be sufficient if the company complies with the provision of the CFS provided in Schedule 3 of the Act. They need not to follow AS, but they have to follow Schedule 3. Exceptions from the preparation of CFS. As per Companies Accounts Amendment Rules 2016, preparation of CFS by company is not required if it meets the following condition. Very important from the examination point of view also. It is a wholly owned subsidiary, is a partially owned subsidiary of another company, and all its other members, including those not otherwise entitled to vote, having been intimated in writing, and for such proof of delivery of such intimation is available with the company, do not object to the company not presenting CFS. So wholly owned subsidiary. It is a company whose securities are not listed or not in the process of a listing on any stock exchange, whether in or outside India. Its ultimate or any intermediate holding company files consolidated financial statement with registrar which are in compliance with the applicable accounting standards. Its ultimate or any intermediate holding companies files consolidated financial statement. Ultimate subsidiary or any intermediate holding files CFS, that is enough. Such company no need to prepare CFS. Provided also that nothing contained in the relevant rule for consolidation of financial statements shall subject. This you understood, right? Ultimate or any intermediate holding company files financial statement. For example, XYZ Limited, holding of ABC Limited, holding of PQR Limited. This ultimate holding, they are doing section 129 CFS. So for this no need to follow the CFS, they are exempted. Provided also that nothing contained in the relevant rule for consolidation of financial statements shall subject to any other law or regulation apply for the financial year commencing from 1st day of April 2014 and ending on the 31st March 2015. In case of a company which does not have a subsidiary or subsidiaries but as one or more associate companies or joint ventures or both, for the consolidation of financial statement in respect of associate companies or joint ventures or both as the case may be. From the point of view of the public interest also, they can give the CG can give the notification for the exemption for preparing CFS. Penal provision that comes in subsection 7. If a company contravenes the provision of this section, MD, whole-time director in charge of finance, CFO or any other person charged by the board with the duty of complying with the requirements of this section, and in the absence of any officers mentioned above, all the directors shall be punishable with imprisonment for a term which may extend to 1 year, or with a fine shall not be less than 50,000 rupees but which may extend to 5 lakh rupees or both. That is the same penal provision as given in the section 128. Who are responsible? These people are responsible. MD, whole-time director in charge of finance, CFO, and other person. Yes, they are there. Then mentioned officer is responsible, and they will have a penal provision of if there is a no person is are appointed or present, then all the directors are responsible. For the purpose of section 129, any reference to the FS shall include any notes annexed to or forming part of such financial statement, giving information required to be given and allowed to be given in the form of such notes under this act. Example: the board of directors of ABC Limited want to circulate unaudited accounts before the AGM of the shareholders of the company. Whether such an act of ABC Limited is tenable? Answer: that at every AGM, the BOD company shall lay before such meeting financial statement for the financial year. Further, section 134 subsection 7 provides that a signed copy of every financial statement, including CFS, if any, shall be issued, circulated, or published along with the copy of each notes, auditor's report, board's report. It follows that the unaudited accounts cannot be sent to the members because they have to sign, right? As per section 134 subsection 7, they have to sign, so they cannot do without auditor's report or the board's report. In order to give auditor reports, it should be audited. So follows the unaudited accounts cannot be sent to members, or unaudited accounts cannot be filed with the register of the company. So such an act of ABC Limited is not tenable. In the next part, we'll see section 130 and we'll continue in the part 2. Thank you.